Hello, I am Eunice Smith. A defendant can make a lot of mistakes between their arrest and trial, and in doing so, may give up their rights without even knowing it. So today, along with our panel, we're giving you information to help you navigate the judicial system. This is Like It Is.
What we see around us, we don't believe that because we want to buy into standards.
We have to prove that we're good fathers. When, as far as the mothers, it's just assumed.
So I'll wait on the check. I'll keep my self-respect first.
I'm a black man trying to save a black man, and I noticed as I looked around the whole room, there's no one helping me.
The reality is, if it affects you, it affects me.
Joining us to discuss the process and the problems suspects face when dealing with the justice system are well-known defense attorney and civil rights activist Michael Coard. Thank you, Mr. Coard, for being here. And tell us a little bit, about your start into criminal law.
Well, the first thing I'd like to say is that I really appreciate you all having me here in the show. That's the first thing. Second thing is, I always tell people that I am not a lawyer who happens to be a black man. I'm a black man who just happens to be a lawyer. And I make that distinction because far too many of us who are fortunate enough to go to college and the law school or the medical school, whatever, we become that thing. We become that lawyer, we become that doctor, we become that dentist, and we think we're part of the American system when we're really not. So when we walk into the room, we're not a doctor in the view of America, we're that black doctor. We're not a dentist, we're that black dentist. We're not a lawyer, we're a black lawyer. But for me, that's a badge of honor. I wear it on my sleeve because the fact that I'm a lawyer today is only a great testimony to my ancestors who fought the good fight to get me here.
Now, right. Tell us, what is the process, navigating through the judicial system, what is the process from start to trial?
Mm-hmm. And I'm glad you phrased it that way. It's technically from arrest to appeal. Okay. That's the process. Okay. And when I talk about legal matters, I always take a page from the book of Malcolm X where he would say, make it plain. Because a lot of lawyers think that if you use these highfalutin, complex terms, you sound smart. Mm-hmm. But you don't sound smart. You sound dumb because the people you're talking to have no idea what you're talking about. Mm-hmm. So I want to make it plain. And here's how it goes. And I'll give you the short version, then if you have follow-up questions, I'll be happy to answer those. Sure. You go from arrest at the beginning to appeal at the end. And it starts when the police officer stops you on the street. Mm-hmm. And let's say, hypothetically, a case happens like this. A guy is leaving his job, gets into his car, drives up Broad Street. He notices that lights and sirens are behind him, and he pulls over. The cop approaches him. The first thing I got to say that's really important before I go any further is that anytime you are a suspect and the police think you committed a crime, sit down and shut up. Don't say anything. Don't say you did it. Don't say you didn't do it. Don't say you know about it. Don't say you don't know about it, because anything you say can and will be used against you. So now the cop pulls you over. You have no idea what's going on. The cop says, sir, license, registration. And I'm going to give you the information from a black suspect's standpoint because the American legal system treats white people different from black people. So the first thing you got to do once the cop pulls you over is, I don't want to be too exaggerated, but if you could put your hands out the window and say, officer, what do you need me to do? But then that sounds too extreme. So you want to have your hands on the top of the steering wheel, holding the steering wheel, just so when the cop comes up to you, both hands on the steering wheel, cop says to you, cop says to you, registration, insurance, all that stuff. And you say, officer, my registration and insurance is in my glove compartment. Can I reach into my glove compartment? You got to ask that. Richard Pryor has this joke about that. And it was funny then back in the 60s and 70s, and it's still funny today, but it's deadly funny. And by that I mean, you really have to ask that question. And I want to be honest, simply because you ask the cop for permission to go into the glove compartment, that doesn't mean that you're not going to get shot. I don't speak like most lawyers who say, hey, young black man, hey, young black woman, just follow the cop's instructions and you won't get beat down. Just follow the cop's instruction, you won't get shot. Well, we've seen so many times where you follow the instructions and you still get beat down, you still get killed. So here's the process. The guy pulls over, cop comes up, license, registration, all that kind of stuff. You ask for permission to get out of the glove compartment. He says yes. And by the way cops always do it, they have the first cop who wants your information to come to the driver's side. His backup, his partner, is always on the opposite side in the rear. So one cop at the driver's side front, the other cop on the passenger side rear, and that way he can see everything. So you ask for permission, the cop says yes, keep your hands up high, get your stuff out, gives it to him. The cop comes back and says, well, sir, there was a bank robbed a couple blocks away from here. Where are you coming from? Now, many people think that if the cop asks you that, the best way to avoid any hassle is just tell them, like, hey, I just got off work. You can, but I advise people not to say anything, because here's how it goes. The cop says, hey, sir, there was a bank robbed a couple blocks from here, and the getaway car fits this description, and you fit the description. So can you mind telling me where you're coming from? And the best thing to say is, officer, I really don't know what you're talking about, and I prefer not to say anything. Okay. And the reason is because once you say, yeah, I just came from the Smith Company, and let's say the Smith Company happens to be right next door to the bank. Well, now you just put yourself at the scene of the crime because you said that. So very quickly, so the cop asks you, my advice is don't say anything, and people...
So when you say don't say anything, you don't mean ignore the question and just stay silent. You're saying just tell them, I'd rather not answer that?
And that's a good question, because you got to phrase it in a way where you don't appear to be a smartass.
Right,
because if they think you're trying to mouth off, then it'll escalate. So the best thing to say is, officer, I don't really know anything about that. I had nothing to do with that. And sir, I prefer not to even talk about that. So you want to say, sir, you want to say, please. So the perfect answer would be, sir, I don't know anything about that, and I prefer not to talk about that. You know, if I ran a red light or missed a stop sign and you want to give me a ticket, that's fine. But the key thing you want to say, and really be polite. And I want to be clear, many lawyers make the argument that if you are polite, you won't get shot and you won't get beat down. You still might, but at least you're doing the best you can do under the circumstances. You obviously don't want to get out of the car and start fighting the cop, so you want to bring it down as much as you can. They tend to escalate the situation. You want to de-escalate the situation. So again, the cop says, sir, there was a bank robbed a couple blocks from here, and the getaway car fits your description, and the bank robber fits your description. Where are you coming from? You say, sir, I don't know anything about that, and if you don't mind, sir, I prefer not to talk about it. And many people think that, okay, by you saying that, the cop is now going to arrest you. And I tell people, well, if the cop had enough evidence to arrest you, he would have arrested you anyway. So by you talking, the only thing you're going to do is to give him information. You just told him you worked at the Smith Company. He knows the bank is right next door to the Smith Company. So now you put yourself on the scene of the crime. You had nothing to do with the robbery, but the more you talk, that's why when we talk about the Miranda decision, and that all about you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. It's a whole bunch of stuff. But the key thing is this. In Philly, when the cops question you as a suspect, they give you this 7-question form. And those 7 questions are based on that Miranda decision from 1966. So the first question is, do you understand you have the right to remain silent? You have to write yes or no. In this case, I would write yes. And then I would put my initial, MC. Then the second question, do you understand that anything you say can and will be used against you? That's when you should stop everything, because think about what I just said. That second question says, do you understand that anything you say will be used against you? It doesn't say for you, it says against you. So if I'm thinking, I'm like, officer, are you telling me that whatever I say is going to be used against me, not for me? And he says, yes, against. I'm like, why would I say anything? If it's going to be used against me, why would I say anything? So people tend to talk, and I got to tell you, about 90% of my murder cases over the last 20 years, 90% involve young black men talking to cops. And the reason why these young black guys do that is not so much that they're beaten into a confession. Even though cops are brutal, they're smart enough not to beat a confession out of you, at least in Philly and most metropolitan areas over the past 15 years, because the process changes. If they arrest me, let's say 12 o'clock in the afternoon, and then they take me to the police station by 1 o'clock, approximately 6 to 12 hours, I have to go in front of a bail commissioner. So if I go in front of a bail commissioner with a busted nose and a black eye and a bloody lip, then that means somebody did that to me. So if they're claiming they got a confession from me, but I got a black eye and a busted lip and a bloody nose, that means they beat it out of me. So because cops now realize that the process has changed from 20, 25 years ago, where now somebody will see you, a bail commissioner will see you, a public defender will see you. You'll be on closed circuit TV. So cops have other ways to intimidate people into making a statement. They can't beat you up anymore because they beat you up. Your lawyer argues that your confession was coerced, and now the suppression motion's filed, and it's all done. So very quickly, before I hear what I know is going to be your great follow-up question. So they stop the guy, license, registration, he gives it up. They ask him for where you coming from. He says, sir, I don't mean any disrespect, but I don't know anything about that, and I prefer not to talk about it. And now if the cop wants to ratchet it up and escalate it, it's nothing you can do about that. So he could possibly drag you out the car and rough you up, but he still doesn't have any evidence about you and that bank robbery. Now, if he's going to rough you up, it's nothing you can do about that anyway. If he's going to punch you, it's nothing you can do about that. You can do something later by suing them, but right now your major concern is not to incriminate yourself, because remember what I said, on that 7-question Miranda form they use in Philly, let's say they get him down to the police station, and now they go through the formal arraignment. Now they have to Mirandize him. And that second question again says, do you understand that anything you say can and will be used against you? Against you. So if this cop asks you where you coming from, you remember, damn, that bank is right next to my business. So now if I tell him I'm coming from work, now that's going to be used against me because I was there on the scene. So now, let's say that the cop grabs you out of the car, roughs you up, says you want to be a smart ass, you want to play the Johnny Cochran role, we're going to lock you up. So now the cop locks you up, takes you into custody, police van, truck comes in and tows your car away. They now take you down to the police station, and here's how that works. So first is the arrest. That's what just happened on the scene. Now you get taken down to the police station and you're processed, which means fingerprinted and photographed. That's where they take your mugshot. That's where they give you a police photo number. I'm going to fast forward this very quickly. That's the second step. Once they do that, now they have usually the interrogation. That's when you forget about the cops who are on the street. Now you got assigned detectives coming in. Hey, Mr. Coard, we want you to know that you're here because you fit the description of this bank robbery. Where were you? And I'm like, as I told the patrol officer, I'm not going to say anything. So they pull out this form and say, hey, we're not trying to force you to confess, but here are certain rights. And now I see that second question. Anything you say can and will be used against you. I'm like, well, I'm clearly not going to say anything right now. They're like, okay, they stop it. They're going to yell at me. They're going to scream at me. They're going to curse at me. They're going to try to intimidate me. But what they're not going to get me to do is sign a confession, because at a certain point in the process, my statement to them, my signature, has to be videotaped. So it's not just a matter of the cops during the trial bringing in my signed confession, but they got to bring in the videotape of their interrogation of me. And they can't be yelling and screaming and cursing at me to intimidate me on that. So before they start videotaping, they'll start yelling and cursing and screaming and threatening and probably pushing me around just to kind of soften me up. Now by the time I turn the cameras on, now I'm ready to confess to everything. But I'm smart. I'm not saying anything. So remember, arrest is first. Second is the processing. Third is the interrogation. Once that doesn't work, you get to the fourth step.
So let's just clarify. At the time when a suspect is stopped,
Yes.
okay, for an alleged crime, all right, and they talk a little too much
Yes.
and incriminate themselves, that information then is provided to the detectives during the interrogation, right, to use it against them.
Right, that's exactly right. And I like the way you framed that, because that information, based on what that suspect said to the cop on the street, is referred to the detective to be used against that suspect. But here's the problem. Before that cop on the street asked any questions to the suspect, that cop was supposed to say, sir, you have the right to remain silent. Anything you say can and will be used against you, because the only reason that cop is stopping that guy is because in that cop's mind, that guy is a suspect, not a witness. If the cop thinks you're a witness and says, hey, sir, which way did those guys go? Now the cop doesn't have to Mirandize the witness. The Miranda decision only applies to suspects. And it's funny, I got a case now, I won't tell you, I'll talk about my old cases that ended in more detail, but in this case, it's ongoing now. my client was stopped, and he did have a gun in the car. And the cop claimed that he stopped my client because the tinted windows. But I was able to show that, and by the way, anybody who gets stopped for tinted windows, the cop just can't come into court and say that you had tinted windows. He has to say that you violated the traffic code, section 4524, which says that the tint was 70% or lower. So if the tint is 70% or lower, that means it's too dark. If it's 71% or higher, then it's legal. Long story.
So what rights does a person have when, because that's common, especially here in this city.
Absolutely.
It's common that people are stopped, for quote unquote, just, their tint is too dark. But if they are within, within the parameters that it can be legally, what rights do they have when they are stopped, when it really is for another reason?
On the street, you have no rights. On the street, the law is what the cop with the badge and the gun says it is. So don't play
deep.
Johnny Cochran, like saying to the cop, hey cop, I want to see your tint meter. Hey cop, is this 70% or lower? You're gonna lose that fight right there. You just take it because you can't win that battle on the street with the cop. Even if you get into a fist fight with the cop, you're gonna ultimately lose. So it all comes down to on the street, don't say anything, just don't do anything. Now, once you get the citation, in my client's case, it was a couple things. One, the cop said that he pulled my client over because of the tinted window, and then once he was approaching the vehicle, he could see my client moving around in the front seat, extending his arm toward the glove compartment. By the time they searched the glove compartment, the gun is in there. And I'm saying to the cop, well, you know that section 4524 of the traffic code says that the tint is illegal if you can't see the inside. So if he had a legal tint, then you couldn't have seen him moving around inside the car and putting the gun in the glove compartment. If you saw that, then the tint wasn't dark enough. And it was so funny because the cop realized that he got caught in a lie. And he then said, well, he approached my client first, asked for license and registration. Once my client gave it up, the cop goes back to his car to check it. But my client's front driver's side window was rolled down, and the sun rays provided enough light for the cop to see inside. It was so bad the judge basically said to the cop, just stop talking because you're making this thing worse. But long story short, we lawyers call that a pretext, where the cop has no legal reason to stop you, so now the cop got to make up a reason. And the reasons would either be that you ran a stop sign, or you ran a red light, or it's common now that the tint was too dark. Long story short, the judge, this was a preliminary hearing this past week, the judge threw out the tint charge, but now we still got to go to trial on the gun charge. But we're going to beat the gun charge because the only reason they got to the gun is because of the tint. Now I want to be clear here because people think that I'm being an enabler, that if these young thugs are running around the streets in cars with guns, then the cops should be able to stop them. But no, they shouldn't, because it comes down to this. It's not a question of what somebody did. It's a question of what the police and the DA can prove. And people say, well, you're playing technical word games. No, I'm not, because the greatest threat to a civilized society is not my one client with a gun in his car, but it's an unchecked police force. Who poses a greater threat, my 19-year-old client with one gun or 7,000 Philadelphia cops with an arsenal? Who poses the greatest threat to society? And it gets worse than that. It's about almost 7,000 cops in Philadelphia. It's about 300 assistant DAs. So you got an army of cops, you got the biggest law firm in the country in the DA's office, and this is an awesome power. So when they come to court, you got the awesome power of the government bringing all that weight to bear on that one kid. The only thing that helps that kid is an attorney like me who's not trying to get him off, who's not trying to beat the case. I always say, I'm not here to beat the case for my client. I'm not here to get my client off. I'm here to keep the government honest. I'm here to make sure that they dot every I and cross every T. And if you're going to say my client had a gun, then stop him legally and get that gun legally.
We have to toss the break, but like it is, we'll be right back. So you mentioned having a 19-year-old, right? Oftentimes when you have young people that fall into situations like this, right? They go to court alone because they don't think that they can actually afford an attorney like yourself.
Okay.
Right? What advice would you give to someone who's watching this right now for them to help them? And because they're convicted oftentimes for that reason, because they don't have the right representation.
The first thing people need to understand is that the whole notion about public defenders being trash is a myth, because most of the best lawyers I know work in the public defender's office. And some of the worst lawyers I know are private attorneys. And those private attorneys couldn't get hired in the public defender's office. So the way the law works is you go to law school, you graduate, you take the bar exam, you pass the bar exam, you don't know anything about real law, and open up your law office, and now people come in and give you money. At least if it's a public defender, that person was hired by the public defender's office, that person was trained by the public defender, and before that person can handle a trial himself or herself, they got to get some background. Now, the only complaint I would have against the public defender's office is that they're underpaid and overworked. About 70% of the criminal prosecution in Philadelphia is done by the public defender's office, about 70%. And the reason is because people can't afford the outrageous fees that lawyers charge. And it is outrageous. Lawyers make up fees. We charge people because we know people are desperate. Nobody wants to go to prison. So if they figure they got to pay you $50,000 to avoid 5 years in prison, we literally, and I know lawyers hate it when I say this, we make up prices. We literally make up prices. We try to figure out how much somebody would pay. Okay, this is a death penalty case. They'll pay every single dime they got. Okay, this is a 25 to life case. They'll probably pay about $50,000 to $75,000. This is a mandatory sentencing gun case. They'll probably pay about $20,000, $25,000. So in most cases, if you're selling a table, for example, you know the price of the metal and the price of the wood and how much it costs to build that table. So now you're going to put a $50 price on that table because there's a connection to the metal and the wood.
Even when they know they're not able to get them off.
That's exactly
right? Or the charges reduced. It's really just robbery.
It's so funny because my fees in state court are different than my fees in federal court. And the reason is most of my state court cases are trials, jury trials. Most of my federal court cases are plea deals. And people are like, why are you pleading your clients out in federal court? The answer is because the feds got a 98% conviction rate. When the feds come at you, they got audio recordings, they got video recordings, they got snitches. So if you're facing 25 to life and they got all this crazy evidence against you, what are you going to do? I'm going to speak very slowly in the next 30 seconds. I got a current case, and I don't want to say too much about it because it's still a current case. It's a federal case where the evidence is very strong. And my client, a middle-aged black woman, wants a trial. And I'm trying to tell her, hey, first of all, they got all your phone records. And I don't know why you took it's a gun running case. I don't know why you got all these guns that you photographed on your phone. So now how do we explain to the jury about all of these guns? It gets even worse. She actually had this scam going on where they had what they call a straw purchase, where you find somebody with no criminal record. And now the straw purchase have all flipped. So now they're going to testify for the government against my client. My client is saying, well, those people are lying. I'm like, it's 7 people who don't even know each other. And there are phone records showing that in every case where the gun was purchased, you and that person are talking a half an hour on the phone before then. Anyway, so getting back to your point, so when I talk to people in federal court, clients, I say, look, the fee is not going to be that expensive because I'm not going to charge you a jury trial fee because I'd be robbing you. I know you're going to be convicted because of what I said about this lady's case. So I'm going to try to work out a guilty plea deal, which means I'm not going to have to pick a jury. I'm not going to have to go through a 2-week jury trial. So the price comes down drastically. But there are lawyers who will, whether it's federal court or state court, they'll charge you the same outrageous fee for either case, and whether it's a guilty plea or a jury trial, which is outrageous.
You mentioned something, if we could rewind a little bit, you said snitch.
Yes.
Right? before the show,
Yes.
you said that you don't represent snitches.
That's correct.
Can you just, for anyone who's watching this, okay, so for them just to understand and
Yes.
know, don't come to Attorney Michael Coard if you are a snitch. What do you mean by that?
If you're going to cooperate with the DA's office and be a witness against your homies, if you're going to cooperate with the U.S. Attorney and snitch on your homies, these are people you grew up with. These are people who you hung out with. These are people you did your dirt with for 5 years, 10 years, 20 years. You knew them and stabbed them in the back. So what can I expect from you?
So it's an ethical reason, really, why
Well, yeah, so it's like now I'm talking to you, but as a lawyer, I might have some creative defenses. And I might say, hey, Joe, I'm not telling you to say X, Y, and Z on the stand, but I am telling you that in cases I had like this, when my client got on the stand, this is what he did or she did. So now Joe will say, okay, is Mr. Coard telling me what I should say on the witness stand? Of course I'm not. I'm telling him what happened in other cases. Now Joe gets on the stand, he screws it up, there's a horrible witness, is found guilty. Who is he going to point the finger at? He's going to say, hey, my lawyer told me to say X, Y, and Z. So if you're going to stab your homie in the back and you've been knowing him for a long time, what are you going to do to me?
Get it.
So I just don't trust snitches. But first, let me define a snitch. A snitch is not somebody who does his or her civic duty by calling the cops when they see an innocent victim attacked. If you're in your house, it's midnight, you see your next door neighbor, little old lady, coming home from work late at night, and some thugs jump on her, knock her down, assault her, and take her money, you should call the police and say, hey, that was little Steve, that was Mike, that
Absolutely.
was Joe, and tell, because you got to
the right
protect
thing to
that
do.
little old lady.
Right.
But if you're involved in it, and you're Steve, and you're Joe, and you're Mike, and let's say Steve gets caught, instead of him just taking the case himself, he tells on Joe. He tells on Mike. That's snitching. Snitching is when a criminal tells on a co-defendant. It's not when you're doing your civic duty by protecting people who are attacked by criminals.
Yeah, but he's going to get less time.
Yeah, that's it. That's it. I mean, that's always the thing. Hey, I'm going to get less time, but a snitch can't be trusted by law-abiding people, and a snitch can't be trusted by law-breaking people.
It's the principle, right? I want to talk to you. I don't know if we should, because this is going to take a while.
Okay.
I want to talk
Give
to
me
you
that
about
signal when I go
about
on and on and on.
about a case that you had that I recall reading about, and it was a domestic abuse matter, and it was a young lady
Yes.
who was on trial, right?
Absolutely.
For murder.
For murder.
Okay, and domestic abuse is near and dear to me. So can you talk about that?
I can
on
talk
record?
all about it because it's
Okay,
over. It ended
it's
about
over.
a month
Okay,
ago.
so she killed her abuser.
Shot him 5 times in the chest.
So how did she end up getting off from that? Because she clearly killed him, right?
The short answer, when you ask how did she get off, the short answer is Michael Coard. But that's a whole nother thing. I'll go into more detail right now. But before I answer that, I just want to make sure, because I tend to get long-winded and distracted, let me spend 1 minute going through the process, and then I'll go back to that case.
Okay, perfect.
Because initially I talked about what the process is from arrest to appeal, so I want to cover that and then get to the particulars.
Okay.
First, you get arrested. After you get arrested, you're taken to the police station where you're processed. That's fingerprinted, photographed, possibly interrogated. Second step. The third step is what they call a preliminary arraignment. That's when you go in front of a bail commissioner who does 3 things. 1, tells you what all your charges are. 2, gives you a preliminary hearing date. And 3, sets your bail. So again, arrested on the street, processed at the police station, you have your preliminary arraignment where those things happen. Then if it's a felony, you have something called a preliminary hearing. The preliminary hearing is where a judge has to decide not if you're guilty or not guilty, but is there enough evidence for a trial? That's the whole purpose of a preliminary hearing. So let's say the judge says, I'm not saying you're guilty, I'm not saying you're not guilty, but I'm going to forward this case for trial. Judge, so that means, again, arrest, processing, preliminary arraignment, and then the preliminary hearing. The judge said there's going to be a trial. You go to the 5th step, which is a formal arraignment. Formal arraignment is basically where you get discovery. Discovery means when the police investigate a crime, they discover information. The stuff they discover, they got to write it up in a report. We lawyers call that discovery. So now at that formal arraignment, step number 5, we get the discovery. That's so we can now prepare for trial. After that formal arraignment, which is step number 5, we get to step number 6. That's what they call a pretrial conference. The pretrial conference is, already got the discovery. I see that the cop did something shaky in the search of my client, so now I want to file a pretrial motion. I want to file a motion to get the gun thrown as evidence because the cops did an illegal search. That's done as step number 6, the pretrial conference. After that's resolved, I'm hoping that I beat the case at that point. Because if I get the gun thrown out, case is over. Let's say I don't. Now we go from step number 6, the pretrial conference, something called the scheduling conference. That's when we get a trial date. And then after the trial date, after we get the trial date, we obviously go in for an actual trial. And then the final step in that process is the sentencing. And then once the sentencing is done, the really final thing is you have the right to an appeal. And the way it works in Philadelphia, there's the municipal court, that's where the preliminary hearings are. There's the common pleas court, that's where the trial is and you were found guilty. Now you go up to the superior court for your first level of appeal. And for the superior court, you just knock on the door of the superior court and say, hey, I got an appeal, I want to argue it. And I mentioned that way because after you finish with the state superior court, you go to the top, the state supreme court. Remember I said with the state superior court, you just go in and appeal. But on the state Supreme Court, you can't just go and appeal. You got to knock on the door and ask for permission and say, hey, I want to appeal. They'll say, what's your appeal about? You'll say it's about X, Y, and Z. They'll say, why should we even hear it? You'll say because of 1, 2, 3. And they're like, all right, we're feeling that. Now come in. That's the process from arrest to appeal. Now, getting back to the case you're talking about, and it's been in the papers, so I can be quite candid.
Yes, it has.
The young lady's name is LaToya Ramshaw. LaToya Ramshaw met this guy, and she met the guy when she was 14 years old. And she, like many misguided young people, she was enamored by his wealth. He appeared to be wealthy. He was a low-level drug dealer in the hood, but he had a car and he had some jewelry. She's 14 years old, very attractive. She saw him, he saw her. He's 19 at the time. So he's 19, she's 14, they connect. They have intimate relations. She gets pregnant at age 14. The baby is born several months later, obviously, so now she's 15 years old. From the time she met him, and she's 14, and he's 19, and then she's 15, and he's 20, from the time she met him, because he was so jealous about her. She's a very attractive young lady, and he would always accuse her of messing with other guys. And not just accuse her verbally, but beat the slop out of her. I mean, he was just brutal. I mean, to this day, I can't understand how a man could punch a woman like he's fighting a man. I mean, it's bad enough to slap a woman. It's bad enough to push a woman. But to actually pummel a woman like you're fighting a man is just crazy. But she stayed with him. And it's so funny because I asked her, I said, LaToya, and it's not really confidential because she shared it with the media. And the question I posed her, I said, LaToya, here you are now charged with murder. This guy's been beating you up since age 14. Here you are 23 years old today. So for about 10 years, he's just beating the slap out of you. I said, how can you stay with a man who abuses you? And she said, I loved him and I still love him. And you're the expert in that whole domestic violence thing. As a man, I can't wrap my head around that. The guy beat you up weekly, beat you up monthly, and you still stayed with him. And now here we are about to go to trial for you killing him, and you're crying over him. And I actually asked her, how can you love somebody who abuses you? And she said, she gave me the best answer imaginable. She said she didn't know. And that was an honest answer. But let's get to the trial itself. So now,
and we're going to revisit that because
there's
layers to that.
And
so
you're
we're
the
talk
expert
about
on that, so I want to hear that. So we get, she has to remember, she first, and it's really weird how this case happened. She and her mother and the DA's office introduced the 911 recordings during the trial. She and her mother are on the phone talking to 911 as the gunshots go off. So you can hear the 5 gunshots. This is how it happened. LaToya and the guy, whose name I won't mention, They had an argument that morning. The incident happened in July of 2019.
And this is in Philadelphia?
I'm sorry, in July of 2018. Yes, right here in Philadelphia, in Southwest Philly.
Okay.
July of 2018, the incident happened. That date is important, July of 2018. So in the evening, there was an argument. Again, he's accusing her of messing with all these guys, all that stuff. And she's like, I'll say his name because I said I wasn't, but it was in the paper, so it doesn't matter. His name is Devin. So LaToya's saying to Devin, I'm tired of this. Every time I turn around, you're accusing me of this, accusing me of that. I'm tired of this stuff. I can't take it anymore.
This
Get
is
out
years
and
now,
don't-"
years and years, right.
And she got, the child is now 10 years old. She's like, I'm just tired of this. I can't take it anymore. So LaToya is living with her mother at this house, and Devin leaves. Devin then calls her that morning. Actually, he texts her that morning, and he says that he got to come back to get his stuff because he left his clothes and bag and everything there. Also, and this is critical to the story, for whatever reason, that's where that love thing comes in. This was her house where she lived with the mother, but she let him keep his gun there. So when she packed up all his clothes and put it in a big plastic trash bag, she put the gun in there. And as he's texting her, he's saying that he wants all this stuff back. He wants his gun. He wants all this stuff. And then they're going back and forth. Now it ratchets up to an argument. And in the text, and I was able to show the jury, he's threatening her. He's saying, if you keep talking like this, then our daughter's going to be an orphan. You and I, either you or I are going to die today. So he threatened to kill her. Less than 3 minutes after this threatening text, he's banging on the door. And while he's banging on the front door, the mother is saying, LaToya, that's Devin. Don't let him in. Don't let him in. So LaToya's running to the front door, making sure it's locked. He can't get in the front door, so he goes around the back. He's banging on the door and still can't get in. Now LaToya's thinking, she's like, okay, if he wants his stuff, she already got his bag with his clothes and his gun in there. She takes the gun out of the bag, and she puts the bag out front door. So now she's thinking, if he's in the back behind the door, I can put his clothes and everything on the, in fact, I stand corrected. What she did was she put the bag next to the door. Everything's in there, including the gun. So she opens up the door to put the bag with the gun on the porch, thinking that he's still in the back. He's running back, so now he's at the front door while she's there. The bag is on the floor between the front door and the porch. He now bum rushes. He knocks her down, starts to beat on her. Her mother's in the back room because the mother heard him banging on the back door. The mother's in the back room. He finishes beating up LaToya, runs to the back room, beating on the mother. Wow. LaToya sees this,
oh, God.
Goes back to the bag where the gun is. Now the mother is on the phone with 911. And you hear the mother say to LaToya, no, and then 5 shots in rapid succession hits him in the chest. He goes down. LaToya is now in a zombified state.
Now, do you know, I'm sorry, do you know, was that the first time he had ever put his hands on her mother?
The first time he put his hand on his mother, on her mother, but he had threatened the mother, and I'm so glad you asked that. When he came in, remember this happened in July of 2018, there was a protection from abuse order in effect from July of 2017 that was going to expire 6 days before she shot and killed him. So the protection from abuse order said he can't even come to the house or around her.
6 days before or after?
He was shot and killed 6 days before it expired.
Right, before.
So it was still, I'm glad
Okay.
you clarified that. So it was still in effect. He knew he wasn't supposed to be there. So once he comes in, now he's beating up the mom. LaToya sees the bag, realizes the gun is in there, gets the gun, comes back to the back room, and after Devin is beating up the mother, he turns around and he's walking toward LaToya. You can hear the mother saying, Toya, no, no, no. And then you hear 5 shots in rapid succession. LaToya then calls the cops herself. So the mother's on the phone first. LaToya is also calling the cops. So I want to make sure I get the sequence right. It was a really exciting and dramatic case. And
yes, it was.
Normally I'm fighting hard for my client because the cops did something wrong or because the DA did something wrong. But I'm fighting hard for her because she was truly a victim. So I want to be clear. The mother is calling 911 while he's beating up LaToya in the room. And then once he comes in toward the mother, LaToya is now on the phone because she sees him about to or attacking the mother.
Right.
It's while LaToya's on the phone that the 911, because people don't realize this, these 911 calls are automatically recorded. So everything's on there. What you say, so you can hear the shots. And you hear the mother yell, you hear the 5 shots, and LaToya is now in a zombified state. What I mean by that?
She snapped, and that situation triggered him hitting her mother.
She got the gun in her hand and she walks outside. And she's just walking up and down the street with the gun in her hand. And mother's like, Toya, get back in because the cops are on their way. They see a black woman walking down the street with a gun, they're going to shoot and kill her. So she comes back in, the mother got to pry the gun out of her hand and puts it down. Let me fast forward to the trial. So now we get, to the preliminary hearing. We get to the preliminary hearing, I'm arguing to the judge, I don't know why they charging her with murder. If they're going to charge her with anything, it's got to be manslaughter. She's innocent of the manslaughter, but the DA has a stronger manslaughter case than a murder case. And the judge said, what are you talking about? And this is where it gets complicated, but I want to make it plain, like Brother Malcolm would say. And I saw your microphone move, so that's my signal to make my answer short.
Go ahead, continue.
But it works like this. There's 5 types of criminal homicides in Pennsylvania. And I say criminal homicide because homicide itself is not a crime. Homicide comes from the Latin word hom, meaning human, and side, meaning killing of. So homicide just means the killing of a human. Soldiers kill other soldiers every day. That's not a crime. Cops kill bank robbers every day. That's not a crime. So it's not that a homicide is a crime. The crime is a criminal homicide. And there are 5 types of criminal homicides in Pennsylvania. The first is first-degree murder. That means it's premeditated. The second type is second-degree murder. That's the felony murder rule. So while I'm committing one felony, robbing a bank, somebody has a heart attack and dies. I didn't shoot them, but they died while I was committing that felony. That's second-degree murder. Then we get third-degree murder, which means I'm trying to hurt the person only, not kill him, just hurt him, but he winds up dead. You and I get into an argument. I pull out a gun and I shoot you in the foot just to hurt you. But it hits a vein, you bleed out and die. I wasn't trying to kill you, but if you died from that, then that's third-degree murder. And then you got voluntary manslaughter, which means you thought you had a good self-defense claim, but you really didn't. I'm at a club. A guy spills a drink on my shoe. He and I begin to argue. I see him reach into his waistband. I pull out my gun and I shoot and kill him. Well, my belief in self-defense was the reason because the guy had shorts on. So I could see he had shorts on, so I had to know he wasn't reaching for a gun. Yeah, he reached into his shorts, but it couldn't have been a gun. That would be a mistaken belief in self-defense. That's voluntary manslaughter. And then you got involuntary manslaughter, which is basically an accident. I'm speeding, not paying attention, lighting a cigarette in my car, and I hit a kid who was on the bike. That's involuntary manslaughter. So first-degree murder, second-degree murder, third-degree murder, voluntary, involuntary. So I'm saying to the judge, you just heard the recording. So you know that he bum rushed the house. You know he was attacking her. You know she shot him with his own gun, and you know that he violated the protection from abuse order when he came in. So judge, we don't have the premeditated. Judge, we don't have the second degree. And judge, we don't have the third degree. If anything, it's the voluntary manslaughter. And at the preliminary hearing, the judge granted my argument. So he knocked out the first, second, and third degree murder at the preliminary hearing. So now we go to trial only on the voluntary manslaughter charge. And once we get to trial, and this is where it gets complicated, but I'll wrap this up easily in 30 seconds, because my argument is something that they call the Castle Doctrine. The Castle Doctrine basically comes from the concept that a man's home is his castle. A woman's home is her castle. So if you and I are arguing on the street and you try to attack me, but as we're arguing, you're like about a half a block away. You're yelling at me, you're cursing at me, you're saying what you're going to do to me. You're a half a block away yelling. I'm right next to my house, so I have a duty to retreat. I can easily walk into my house if I'm on the street. But the Castle Doctrine says that if this stuff happens inside my house, I have no duty to retreat. If this same thing between LaToya and Devin had happened on the street, she could have been found guilty, possibly. But since it happened inside...
And their child, was their child there at the house?
The child was not, fortunately.
Oh, okay.
The child was not.
Okay.
So since it happened inside the house, I argued the Castle Doctrine. The Castle Doctrine says you can use deadly force against somebody who you believe is about to use deadly force against you. And the court and the decisions go on to say, well, how can you determine if the person was going to use deadly force? In our case, it would have been hard because Devin wasn't punching anybody at the time she shot him. Devin didn't have a gun in his hand at the time she shot him. But the law says that if there is a legal reason for which the person wasn't supposed to be in the house, then that's
there
in
was
your
a
mind.
history.
That's exactly right. So like I said, if he was going to do this, he should have looked at the calendar and come 7 days later.
No, but he knew. Now, had he violated the restraint, I'm sure within 2 years, it was 17 to 18.
Exactly.
He had violated it multiple times, I'm sure, right?
But she never called the police.
Right.
Absolutely
Because
never.
if I'm not mistaken, this is the typical relationship, especially DV relationship stuff, back and forth, a lot of back and forth, and off and on. And she was still intimate with him.
Yes.
Right. Okay.
In fact, you sound like a lawyer because the DA, the prosecutor, tried to tell the jury that he really didn't violate the order because she had him there the night before. They were intimate. She had him there days before. They were intimate. So she was letting him come and go. But
there was a lot of mind control and manipulation, and that's the part of domestic abuse.
That's
that
exactly
mental control that he had on her.
You hit it on the head. And I got the judge to basically say to the DA, what the hell are you talking about? Because no matter what the woman says, you can't violate the order. And the reason why the courts don't care, the woman could call you up and say, babe, come on, I've made a big dinner for you, come on over. You got to say no. There's an order. And the reason why the woman can't subvert or undermine the order is because if she could, every man would intimidate the woman. Every man would threaten the woman. Every man would pay off the woman. So the judge is saying, you can trick her, you can intimidate her, you can pay her off, but I'm the judge. I got this order saying you can't be around her, so if you want to change it, come to me, don't come to her. So whether she let him come into the house that day, whether she had sex with him the night before, none of that matters. He violated not her court order, he violated the judge's court order.
Absolutely. So,
well, let me say this.
Oh, okay.
One thing, because I really got to tell you the ending, because usually when I'm yelling and screaming in court with my clothing, or it's an act, I'm not really hyped up like that, but juries want to see you do that whole law and order thing. So you do the law and order thing. But I had this real righteous indignation for LaToya because the DA kept referring to Devin as the victim. And in my closing argument,
because
I
he's
said,
the deceased.
Because that's exactly right. You're definitely a lawyer, because that's the legal term, decedent. So I get up in that closing argument, I said, ladies and gentlemen, I mean no disrespect to Devin or his family, but he wasn't no goddamn victim. And that was my phrase. I said, because a victim is somebody who's victimized. He wasn't victimized. To call him a victim because he's dead, an example I used is the bank robber comes to the bank to rob the bank. The guard shoots the bank robber. Is the bank robber the victim? No. The guard shot him, he's just a decedent. So I said to the jury, he's not the victim, he's the decedent. She's the victim. And I actually had these color photos blown up of at least 7 or 8 of the assaults by him against her. Attractive young lady, but her eye was, it was like she fought Mike Tyson. It was that bad. In fact, it was so bad that she testified. So I had to show her these photos so she can tell the jury what they were. And she was crying as she was explaining how he punched me in the face because I was hanging out with my girlfriends. He punched me in the face because I stayed at the club too late. Again, he's punching her like she's a man. So in my closing argument, I got this righteous indignation, and the only argument or dispute I had with the jury is that they took so damn long to find her not guilty. When I say too long, I thought after my closing argument, they were going to come back in 10 minutes saying not guilty. But instead of them doing it in 5 minutes, they came back not guilty in about, say, an hour and a half, 2 hours.
Now, if a person is in a situation like hers and they're denied a public defender or a court-appointed lawyer, what is their position? What options do they have?
I'm glad you asked it, because this is the way it works. Once part of that processing I mentioned right before your preliminary arraignment. Remember, you get arrested, you then get processed, and then you have your preliminary arraignment. Preliminary arraignment is where the bail commissioner tells you what your charges are, tells you what your preliminary hearing date is, and sets your bail. Now, the reason that the bail part is important because You actually have to talk to bail workers who work for the city. So now they want to know, hey, Mr. Coard, what's your income? Where do you work? How much do you make? So now I'm saying I got no money in the bank. I'm unemployed. So once I tell them that, they automatically will appoint a public defender. I'm a private attorney with one exception. I take court appointments on death penalty cases. And the reason why I take court appointments on death penalty cases is because I'm personally opposed to the death penalty. I don't think anybody, anytime should ever get it. People like Mike, why would an experienced lawyer like you demean himself by being on the court-appointed list? And my thing is this, because I oppose the death penalty, I would represent these people for free because I'm opposed to the death penalty. When you have a capital case, very rarely would the person get off, because in all my death penalty cases, and I told you before we started recording, in the past 10 years, every high-profile murder case where a cop was killed, I represented the defendant. From John Lewis to everybody. John Lewis, the case where the officer was shot and killed at Dunkin' Donuts. So my point is, because I opposed the death penalty, I agreed for judges to appoint me to those cases. And people say, well, Mike, why would you take and if the city pays me, I'd be lucky to get $15,000 to represent that person. If the guy walks into my office or his family, the fee could be anywhere from $35,000 to $50,000. So why would I take a $50,000 paid case for $15,000 with the court? The answer is, I wouldn't want to tell the judges, but I would take that case for free. And the fact that you've given me $15,000 for a case that I would take for free, that's like icing on the cake.
I've seen the movie Just Mercy.
Oh, greatest movie ever made.
Awesome.
Brian
Fantastic.
Stevenson, the greatest lawyer since Thurgood Marshall.
All right, stay right here. Like It Is, we'll be right back. Michael Coard, thank you. Attorney Michael Coard. At ESQ.
Absolutely.
Thank you so much for being here and having this candid conversation with us to just, give the most resourceful information about the law and the judicial system. Any key information that you want to close with?
Absolutely. First of all, thank you for having me. This wasn't really an interview like I expected. It was more like a conversation, which made it even better.
And you're going to come back again
and
for
no
another
doubt.
conversation.
So I appreciate you and the staff and everybody because you all do a great job. I want to spend a minute just going into the whole cell phone thing because everybody has a cell phone. And people have embarrassing stuff on their cell phone. People have incriminating stuff on their cell phone. They have criminal stuff on their cell phone. So the question is, can the cops make you give up that information from your cell phone? The answer is, it depends. And here's the legal advice. If access to your phone is a fingerprint, yes. If access to your phone is facial recognition, yes. But if access to the phone is a password, no. And I love your expression like, Mike, what are you talking about? It comes down to this. Here's the case, a case called Commonwealth versus Davis, where a guy in a suburban county here in Pennsylvania was doing some criminal stuff. The cops found out about his criminal stuff. They had a search warrant. They got into his house. They got his computer. And they found some incriminating stuff on the computer, but there was other stuff that had been encrypted. The guy had a 64-character password. And the cops, through the Attorney General's office, they used their great forensic staff. Nobody could crack the code, but they knew there was something in there. So when the case was scheduled for trial, the prosecutor said, Judge, there's some stuff on this phone, on this computer. I'll get to the phone in a second. He won't tell us his password. Judge, you gotta order him to tell us the password. And the guy's lawyer was smart, like, Judge, I'm not gonna have my client incriminate himself by telling this. So no, we're not getting anything. The judge held the defendant in contempt of court and gave him like 30 days in jail. And the lawyer was smart. Judge said, okay, here we are in the court of common pleas. I'm going to appeal to the Superior Court and ask the Superior Court to overrule that trial judge to say, no, he don't have to give up his password. Superior Court said, yes, he does. He got to give up his password. The lawyer said, I'm not taking your answer, and went up to the state Supreme Court. In November of 2019, just a couple months ago, the Supreme Court issued a case that everybody should know about, and it goes like this, Commonwealth versus Davis, 2019, November. It says this: if that judge had ordered that defendant to give up his fingerprint, he would have had to give it up, just like they can force you to take a breathalyzer or a blood test, because that's a physical thing, your fingerprint. If his computer had access by his face, facial recognition, then he would have to put his face up against it, because that's physical. But if it's a password in his head, the government should not have the authority to go into the essence of who you are. So anybody who has access by phone, by thumbprint or fingerprint, take that off your phone. When I say phone, I mean phone, laptop, desktop, whatever. If it's your fingerprint, the judge can order you to give it up. If it's your facial recognition, the judge can order you to give it up. But if it's simply in your head, the judge cannot do it.
Wow.
So make sure for all cell phones, get rid of the fingerprint, get rid of the facial recognition, and go back to the password. And damn it, don't write your password down anywhere, because the cops find that, they can see it, now they got you. If it's in your head, they can't get it.
You host a radio show, if I'm not mistaken, right?
Absolutely.
All right, tell us about it.
Actually, it's two things that I host. One is called TV Courtroom. The other is Radio Courtroom. Radio Courtroom is here in Philly every Sunday from 11 a.m. to 1 p.m. at WURD 96.1 FM. And I'm proud to say here at PhillyCam, once a month, first Friday of each month, I do the TV Courtroom. And in both situations, I talk about the law, but I talk about it similar to what we did today in a conversational kind of manner, following what Malcolm X said about make it plain. So if you want to know about the law in an easy to understand way, WURD 96.1 FM every Sunday at 11 a.m. or PhillyCam 3:30 first Friday of each month.
Now, can people call in and ask questions that they have about anything pertaining to the law?
The answer is yes, and it's funny you ask that, because a lot of lawyers don't like the fact that I'm giving free legal advice over the phone. But yeah, I have experience in criminal law primarily, but everything else, child custody law, child support, divorce, parking law. By the way, I hate the parking authority, so I would help anybody who wants to go after that. So yeah, any type of law, I have basic information to discuss with people, so they get free legal advice from a black man's perspective.
Awesome. Once again, how can people find you again? WURD.
Yes, a number of ways. They can find me on WURD 96.1 FM every Sunday at 11 a.m. They can find me here at PhillyCam TV Courtroom first Friday of each month, 3:30, or on social media, Facebook, Twitter, Instagram, under Michael Coard, MICHAELCOARD, or just call the office, 215-552-8751.
Fantastic. You're about to be my best buddy.
Okay.
Thank you, Attorney Michael Coard. Thank you. We would like to thank Attorney Michael Coard. The information discussed can be found on the Like It Is Facebook page. Like It Is airs Saturdays at 5 p.m. on Comcast channels 66 and 966 and Verizon channels 29 and 30. Previous episodes can be viewed on the Like It Is YouTube channel. Now, from the Like It Is crew and our panel and the studio audience, thank you for watching. Have a great day.